Thank you. Yes. Ms Ward.
My lords, my lady, this is the third case in relation to the withdrawal agreement to reach this court. The previous two, which you have in the bundle, AT and Selic, have both been refused permission to appeal to the Supreme Court this week. My learned friend Ms Snive and I are the only counsel with the perhaps dubious privilege of having appeared in both of those cases, and indeed the other main case on the withdrawal agreement brought by my current client, the Independent Monitoring Authority, and decided by Mr Justice Laing, which also appears in your bundle of authorities. Ms Snive has argued consistently for the Secretary of State, and I've been arguing for whichever intervener will have me. I say that not to be self-deprecating, but to emphasise that this is a new and complex area of law, and whichever of the parties succeeds in persuading you, the court, that we've cut through the complexities here to the right, most elegant solution. If we have done our job at the bar, it may be that that seems like a clear and obvious solution to you. But for applicants at the end of the transition period, and that's what we're specifically concerned with here, during the period when the 2016 regulations and the new bespoke arrangements that the UK introduced under Article 18 of the Withdrawal Agreement, which we often refer to as the EUSS, and including, for these purposes, the Appendix EUFP, which applied to entry clearance applications, those two systems operated in tandem, and applicants faced with that dual system did not have the benefit of any of the analysis that we are seeking to put before this court. Now, as set out in our written submissions, my client's concern in this case is limited to the interpretation of the withdrawal agreement, and specifically Article 10.3,
Yes.
picking up points that were left over in that sense in Selic because they ultimately didn't arise in the facts of that case. And my client's concern is for the group who are affected by the need to make two applications in order to ultimately obtain resident status under the EUSS. So the group who had to first apply under the 2016 regulations to then get the document that they needed to accompany their application under the EUSS. Prior to the UK's exit from the EU, the position that you've been shown the 2016 regulations, which are the successor to the 2006 regulations, the first implementation, domestic implementation of the 2004 directive. Prior to EU exit, you had two groups, still have two groups, EU nationals, EEA nationals and family members, as defined under Article 2.2 of the directive, who had declaratory rights, although they could apply for recognition of those rights under the 2016 regulations. And of course, once the EU settlement scheme was introduced, they were directed to that channel only, because after the end of the transition period, they would need a document to confirm their residence rights. Effectively, therefore, but at that point, they are put in the position that extended family members and durable partners, those who provision was made for in Article 3.2 of the directive, were always in, with the need to apply for a document in order to be able to exercise or to have conferred the rights available under the directive as a matter of EU law, now those preserved by the withdrawal agreement. So to some extent, the EUSS put everyone else put everyone in the same position. But, of course, as you've seen, the requirement was maintained for extended family members and durable partners to have made a prior application under the 2016 regulations, which, in order to obtain the document, which they then needed to make their EUSS application. And as we know from the evidence in this case, that application could be made from the same starting web page, we'll look at again very briefly in a moment. That obviously created at least the potential for the wrong application to be made. Now, as I've said, our primary concern is Article 10.3. We say that's key to this case, and that actually it gets one to the result contended for by the appellant, albeit by a slightly different and perhaps more direct route. The breach of the withdrawal agreement, in this case, we say, is the failure to conduct the extensive examination of personal circumstances that is required by Article 10.5. That's not been done in this case, and we say it remains outstanding. It was treated below, and one sees this in formulation of the third issue by the Upper Tribunal, as an example, as a question of whether Article 18 of the withdrawal agreement required the respondent to treat Ms Siddiqa's application as having been made under the 2016 regulations, so to treat it as something it was not. We say on a proper analysis, the question is simply whether there was an application that brought the appellant within the scope of the withdrawal agreement. And then, of course, what follows from that. So what I propose to address the court on in the time that I've been permitted is firstly to very briefly, I hope, but revisit in a little more details the withdrawal agreement provisions, including Article 10, but going a little bit wider to show the court the context, to explain how those provisions fit together with the directive, and to make some points of emphasis in relation to what the case law on the directive tells us, and then to deal with how that all fits in to the appeal that's before this court. I'm going to try, so far as possible, not to ask you to turn up again that which you've been shown already. I'm conscious, however, that it is very difficult to follow quite a lot of this without having the provisions physically in front of you, so I apologise in advance if we do perhaps need to turn up.
And you've had the advantage of having been in all the cases already, Ms Ward. Imagine how difficult it is for those of us that haven't had that pleasure.
I did preface that with the word dubious. So, dubious advantage. The withdrawal agreement.
Yeah, so we need to go over that, don't we?
We do need to have a quick look at that.
Okay.
A few extra points that didn't perhaps come out so that's tab 1 of your binding of authorities. And beginning at page 5.
So you don't think there's anything in the recitals or preamble?
Yes. Can I just check those? Am I right that all members of the court are using the hard copies rather than electronic bundles?
Well, I've got both.
The Lord's multitasking, as always.
Sometimes affects how one refers to things, so I'll make sure I cover both. That's not a problem. So I do want to make a point on the site, on the preamble.
Okay.
Beginning at page 5.
Yes.
Because we're all agreed the correct approach to interpretation of the withdrawal agreement is as set out in the Vienna Convention. You have regard to the objects and purpose, and the best evidence of those is, of course, what the parties said they were. And we have at the bottom of page 5 the last 2 points there, stressing that the objective is to ensure an orderly withdrawal of the United Kingdom from the Union and Euratom. And then the final one on that page, recognising that it is necessary to provide reciprocal protection for Union citizens and United Kingdom nationals, as well as their respective family members, where they have exercised free movement rights before the date set out in this agreement. So orderly withdrawal, protection of rights for those who have exercised free movement and their family members.
Right.
And then so continuing in that bullet point, at the end there, to ensure that rights under this agreement are enforceable.
Yes.
So my learned premise slide has asked me also to draw your attention to the top of page 6. Resolved to ensure an orderly withdrawal through various separation provisions aiming to prevent disruption and to provide legal certainty to citizens and economic operators.
Right.
So,
certainty.
Perhaps none of that particularly startling, but I do place emphasis, of course, in particular on the final point on the final preamble on page 5, protection of citizens, family members who've exercised right of free movement, and need to ensure their rights are enforceable.
Mm-hmm.
So, one then has the common provisions part 1, beginning on page 7.
Mm-hmm.
And if I could just pause on Article 2 on page 7, the definition of union law. That covers, amongst other things, treaties. Yep. And at the end of bullet point A1, the Charter of Fundamental Rights of the European Union. And perhaps just keeping a finger in there, it's worth at this stage, which is the only reference I intend to make to this case, to see what the Court of Appeal in AT had to say about the Charter.
Are we relying on any charter rights here?
Well, my Lord, we refer in our skeleton to the paragraph number rights. I keep confusing it with the article of the Charter. At paragraph 37 of our skeleton. Oh. So, this is why I get the numbers confused. Paragraph 40, Article 41. So paragraph 40
of your skeleton.
Of our skeleton argument.
Yes.
Have we got the charter then?
We do have the Charter, my Lord. That's the 4th tab in the bundle of authorities. You have some extracts from it insofar as they
And including Article 41.
And Article 41 is on page 88 behind tab 4.
I mean, does this really help? Because if the Secretary of State's right, you had a very quick decision, or they had a very quick decision, which was properly dealt with, because you used the wrong form. And if they're right, then there was a failure to take into account relevant bits, but no one was complaining about the absence of good administration.
Well, the right under Article 41 is to have affairs handled impartially, fairly, and within a reasonable time. So it does import considerations of fairness. And that's
Good administration doesn't quite mean what we might think it means.
well, good administration doesn't necessarily mean quick administration.
No, but I mean that doesn't help because the Secretary of State said it's perfectly fair to reject a hopeless application, and the appellant says it's completely wrong to have ignored the fact that I meant to do the other one. It just doesn't take us any further forward, and you get into all the problems we had in AT, which I'm not sure we necessarily need to get a revisit.
My Lord, there's absolutely no need to revisit AT. What the Court of Appeal has said, and if I perhaps ask the Court in their own time, conscious of the time allocations in this for all submissions, to read paragraphs 83 through to 87 of AT. It's behind tab 14, beginning on page 410. It's a lengthy passage. I don't ask you to do it now, but the nub.
83 and 87.
Yes.
This is Lord Justice Green, isn't it?
Yes. Given
With whom my Lord agreed
which,
in a separate judgment. Is that right?
Agreed
in
with
a
the result.
separate short judgment, yes.
But I mean,
bits. Anyway, it doesn't matter. I mean, if you really want to get into this for the purpose of Article 41, fine. But I'm not sure it really takes the argument very much further forward.
I think it might be interesting, Mr. Ward, to see what the Lord says, but we might use more of your time than you want to.
Well, absolutely, and the point I'm making, the purpose of showing the court Article 2, which, of course, I'm conscious, my Lord Justice Dingemans has had a number of members of the bar attempt to explain to him previously,
You're going to have another
is
go,
simply
right?
to demonstrate that that for the purposes of interpreting the withdrawal agreement, we'll come on to that in Article 4, union law includes the treaties, the charter, the general principles, and then when one comes to Article 4 over the page, on page 8, in particular, Article 4.4, the bottom of that page, the provisions of this agreement referring to union law or to concepts or provisions thereof shall in their implementation and application be interpreted in conformity with the relevant case law. The Court of Justice of the European Union has done for the end of the transition period, so it's case law, and also at 4.3 applied in accordance with the methods and general principles of union law. So you have union law defined in Article 2, the methods and general principles, and this is worth what Lord Justice Green said in AT, is that the Charter does include general principles.
Yeah, but if you also look at paragraph 82, the first sentence, he says the Charter applies, albeit within limits.
Yes.
And it's those limits that can create lots of issues.
They can, my Lord. Happily, not issues that it's necessary for us to go into in this case, but just to give that union law context to the interpretation when one comes then to Article 10
Of the agreement.
of the withdrawal agreement. But just before one gets there, and just to show the court the rest of the context, there's on page 9, Article 5, the obligation of good faith. And then one comes on page 10 to part 2, the citizens' rights part of the agreement, the part, of course, that my client is charged with monitoring the effectiveness of law. Now, it's perhaps helpful, I think you've been shown the directive in some detail, but just to have a finger in, starting on the definitions article, Article 9, on page 10, the definition there of family members, which means persons, irrespective of their nationality, who fall within the personal scope provided for in Article 10, which we'll come on to, but are also family members of Union citizens or United Kingdom nationals as defined in 2.2 of the directive. That, and you've seen it already, is to be found on page 44 behind tab 2. But it's spouse, registered partner, direct descendants under 21, direct descendants who are dependent, and dependent direct relatives in the ascending line, in each case including those of the partner. So that's the limitation in Article 2.2, and we see as well in 9A2 that family member for these purposes means persons other than those defined in Article 3.2 of the directive, who, effectively that's Zambrano carers of EU nationals, which is happily what the guidance handed up by Mr. Biggs this morning says about that, but just to be clear, that's who we're talking about. So people who fall within Article 3.2a, which again, you've been shown already, but for the court's note, behind tab 2 on pages 44 to 45, those who fall within 3.2 are any other family members, irrespective of nationality, who don't fall. So there's a very clear division between Article 2.2 family members, Article 3.2 other family members, who are either dependents, have serious health grounds, or have serious health grounds that require personal care of a family member by the union citizen, and then B, durable partners. So, and this, of course, dependent family member case, Selic was a durable partner case, but for these purposes, both within Article 3.2.
Okay, so family member under Article 9.
Yes.
Yes?
Yeah. Well, no, so neither is family member within that definition in Article 9. That's the point and the reason why we find ourselves in this position. Family members under Article 9, you then see
Other than that, yes.
in Article 10 on the facing page, by E and F, family members, as that term is defined in Article 9, who are either here with the union citizen before the end of the transition period, and that's E1, or who were outside and want to come in after the end of the transition period. That's E2, births, adoptions, etc. are dealt with, all under E1. But then from 10.2 through to 10.5, you have provision for the Article 3.2 people.
Right, thank you.
In language that it's common ground, mirrors Article 3.2 of the directive to such an extent that these are concepts of of union law to which the interpretive obligation, the interpretive approach set out in Article 4, 3 and 4 applies. So 10.2 at the bottom of page 11, persons falling within points A and B of the directive whose residence was facilitated by the host state in accordance with national legislation before the end of the transition period. So that's people who applied under the 2016 regulations, had their residence card, and for those people, they shall retain their right of residence in the host state in accordance with this part, provided they continue to reside in the host state thereafter. So their existing rights of residence already obtained are preserved. 10.3 then over the page says that paragraph, so the preservation of rights of residence, will also apply to persons, same people, who have applied for facilitation of entry and residence before the end of the transition period, and whose residence is being facilitated by the host state in accordance with national legislation thereafter. So these are the transition cases, straddle cases, people who've applied beforehand but it's not been dealt with by the end of the transition period. And just for completeness, and so the court has a full picture of Article 10, we have 10.4, which is about durable partners who were not here at the end of the transition period, but for whom the right to apply to join their durable partner, EU national, who was here. Of course, I'm always talking from the perspective of the UK. Same would apply for the other way round, but can apply to join their EU national partner in this country under 10.4. So for extended family members, like the appellant in this case, it's wherever you are at the end of the transition period, that's it, you've either made your application or you haven't. For durable partners, there remains the possibility to apply to join in the UK or other host state. But then importantly, then we have, again, mirroring the closing words of Article 3.2, directive, Article 10.5, the withdrawal agreement, in the cases referred to in paragraphs 3 and 4, so that's either the straddle cases undetermined before the end of the transition period or new durable partner applications, the host state shall undertake an extensive examination of the personal circumstances of the person concerned and shall justify any denial of entry or residence to such persons. So word for word there, the closing words of Article 3.2. Just while we're in the withdrawal agreement, you've been shown Article 18 in some detail. There's just one further submission that I wanted to make in relation to Article 18L.
I'm so sorry, just before you leave 10.3, I'm probably being quite slow. So is it your submission that the appellant falls within 10.3 squarely within
Yes.
the language? Because the bit at the end, and whose residence is being facilitated thereafter,
Yes.
doesn't yet apply because
No.
she hasn't got to that stage.
No.
Yeah, okay. I just wanted to be
But that,
clear that I was following.
the scheme has to make sense.
Yes, sure.
10.2 applies to people for whom there's already been a determination.
Yeah.
10.3 is you've applied but it's not yet been determined.
Yeah.
And of course the importance of that is that when that application is determined, and if it's determined in the applicant's favour, then a document is issued that would enable an application
Under the EUSS.
under the EUSS.
Yeah.
And one sees that, so that's the point I wanted to make it in relation to 18L, beginning at the bottom of page 15. So talking about family members, this is a slightly odd use of, one might say slightly odd use of language using the term family member there who falls within Article 10.2 or 10.3, because we've just seen that those people are not family members as defined in Article 9. And the same point was picked up by Lord Justice Laws in the CS case that you were showing this morning. And that's, I don't ask the court to turn it up now, but it's paragraph 6 for the court's note and it is sidelined to make that point that sometimes the term family member is used to encompass something slightly wider than the Article 2.2 definition or the Article 9 definition. And the family members falling within 10.1E1, that's the applications from out of country, or Article 10.2 or 10.3, can only be required to produce the supporting documents that are listed there, include the documents attesting to the existence of family relationship, registration certificate for sponsor, evidence of dependency for the adult children and sending relatives, and then little 4, document issued by the relevant authority in the host state in accordance with Article 3.2 of Directive, the 2004 Directive. So, quite clear from that this 2-stage process was contemplated by Article 18, and it's not my case that some form of rolled up process is required, or that the application made under the new provisions, the USS family permit provisions, ought somehow to have been treated as, or dealt with under the 2016 regulations, and then led to the grant of status under the Article 18 scheme. This case is about how
It's about the
states,
earlier stage.
yeah,
in the
how
process.
states are required to treat attempted applications, which was in this case informed of the wrong application, but which clearly sought to access the rights that were afforded under Article 3, under Article 3.2 of the directive, carried over into Article 10 of the withdrawal agreement. And
So to anticipate, your case is that this isn't about the interpretation of 18.0 at all, 18.10.
no, what I say about Article 18 is that what it does is demonstrate what the parties to the withdrawal agreement thought a good application process would look like.
Yeah. So it's kind of indirectly relevant.
It is.
Yeah.
And the agreement has to be read as a whole, and that's an indicator of, say, how the parties saw fair dealing with an application. Opportunity to correct errors, opportunity for redress, proportionate approach. And that's emphasised in my submission. My then Mr. Biggs took you through Article 21 and the way it incorporates by reference those parts of the directive, including Article 15 and Articles 30, 31 and 28. I don't think there's any more detailed submissions on them than this. It's quite clear from Article 21 that, again, those concepts of proportionality and need for full examination of circumstances are again incorporated by reference expressly in Article 21 whenever there's a decision to restrict the residence rights of the persons referred to in Article 10. Now, as I say, my own friend Smythe's submission is that there are no residence rights until you're through the article, I think, until you've had a determination in your favour under Article 10. It's not perhaps entirely clear what the residence right is, but my submission is that Article 10, although it's in terms of scope provision, is making provision for rights of residence, as it does on its face, for those who have either applied and been successful or have a pending application under Article 3.2.
And how does this fit with the grounds of appeal?
How does it fit with the
Because you're an interested party or intervener,
Yes.
and the appellant has set out clear grounds of appeal,
Yes.
but this isn't one of them.
So, my lord, the appellant's ultimate ground of appeal is there's a breach of Title 2 as part of the withdrawal agreement, and that's what I support. But I'm making submissions as to the interpretation of Article 10, which is a matter that my client is properly interested in, and actually contending for the same outcome as the appellant.
Yeah.
So, my Lord Lady, then the cases on Article 3.2, I want to draw attention to, take you back to two of them. Rahman, which is in the Authorities Bundle tab 38, using the whole, certainly in my version of the Authorities Bundle, it's in the second folder.
Yes, that's right. Yep.
And if I ask you to start it, have a quick look at the questions that were posed in that case for the Court of Justice at paragraph 17 on page 1066.
Yes.
First of all, does Article 3.2 require a member state to make provision to facilitate entry or residence for a member state to the class of other family members who are not nationals of the EU who can meet the requirements of Article 10.2, so that was in relation to provision of documents. And can such other family members referred to in question 1 rely on direct applicability in the event they cannot comply with any requirements imposed by national legislative provisions? Well, that's reformulated by the court as it often does, and answered then paragraph 18 and following. It says paragraph 18, it does not oblige, Article 3.2 does not oblige the member state to grant every application for entry or residence submitted. But you were taken through these passages and Mr. Biggs this morning, so I don't propose to read them to you again, but just to draw the court's attention to the penultimate part of the decision paragraph, which is paragraph 26 on 1069. The member states have a wide discretion when selecting the criteria. That's the criteria for facilitation of entry and residence. They must be consistent with the normal meaning of the term facilitate and the words relating to dependence used in Article 3.2, and must not deprive that provision of its effectiveness. So the essence of the entitlement set out at paragraphs 21 to 24 and then culminating in that expression at paragraph 26 is the entitlement to an individual decision based on an extensive examination of personal circumstances, which of course is the very thing that the appellant in this case has not had. I ought also to touch very quickly on questions 5 and 6 in Rahman, because Ms. Smythe says that by analogy with the court's answer to those questions, which are at 1070 through to 1071, they show that she says that the application process is outside the scope of the directive. But we've already seen, with respect to in those earlier passages, that whatever the position in relation to the particular requirements, and there it was the requirement to continue in the relationship of dependence in order for the residence card to, as a condition of the residence card, whilst that, the court said, falls outside the scope of the directive, we've already seen that the way in which the member state sets up its system cannot deprive the provisions of Article 3.2 of effectiveness. So to that extent, they are bounded by EU law principles. And the other case that shows that, and again, you've seen it already, is Bangor, which is in the authorities, hopefully in the first bundle, tab 27, beginning at 837.
9.
But I've got 837, right, so
Sorry, what was
yes,
what tag?
tab 29.
Second bundle.
Right. So
Yes.
that case was, and one can see this from descriptions of facts in the head note, a Surinder Singh type case. So a British citizen who'd gone abroad and sought to return with his non-EA national wife to exercise the rights established by that case. But the court held here, and one sees this in paragraph 2 of the holding on page, so that's in the head note on page 838, that Article 3.2 of the directive was held to be applicable by analogy. So far as perhaps when rereading this, the court sees little wrinkles in how is this an Article 3.2 case, that's how it's applied by analogy. And then the third holding there, so on page 838, was referring at the end to paragraphs 48 and 52 of the judgment, was that there had to be a redress procedure. So to that extent, again, the procedure bounded by minimum requirements of EU law. And paragraphs 48 through to 52 on page 850 so that, again, I've made the same mistake as
This is the Advocate General.
I've turned to the, I've actually got in my note 874. But I've been beguiled by the sidelining. Yes, 48 to 52. So
Of the judgment.
of the judgment, beginning at the bottom of page 874 of the authorities bundle and carrying on to page 875.
Yes, well, we have to determine what in particular. Do you rely on 52 as well?
I do rely on 52, and I
Yes.
rely also, just to make the point that paragraph 49, well, first of all, paragraph 48 and the requirement for an effective remedy. Paragraph 49 says in terms that the safeguards in Article 31 of the directive, well, yes, in Article 31(1) are applicable. That paragraph 50 refers to checking whether national legislation remains within the procedural bounds. So an exercise that would almost by definition embrace whether procedural bar is depriving someone of effective protection. And paragraph 51 repeats the emphasis on the need for a post-factual review. So what I say about Bangor is that it supports the view that the principles of effectiveness, good administration, proportionality are carried over, are inherent in the Article 3.2, in the interpretation of Article 3.2, and therefore in the interpretation of Article 10.3 of the withdrawal agreement. Now, of course, in this point my own friend has made you, I do just want to emphasise in the time remaining to me, until the cliff edge was created by the end of the transition period, the requirements for valid application simply did not fall to be determined. So there is no previous EU case law, right, as Justice Dingemans asked and received that answer this morning, that deals with what is an application, what do you have to treat as an application. And that's, of course, because if a state wanted more information, wanted a different form, they simply had to say that. It could be provided, and there was no cut-off. So the interpretation of what is an application for these purposes falls to be determined for the first time in the context of the withdrawal agreement. And it falls to be determined in this context. Firstly, the context of the cliff edge that exists, and as Mr. Justice Laing put it in the IMA JR case, which is tab 17 of your bundle of authorities, paragraph 148, the consequences of being shut out can be relevant to the interpretive exercise that has to be undertaken. The second part of the context is, as I opened with, the existence of the parallel systems during this period, when the 2016 regulations were still there. Optional applications could be made under them, but those people were actually being directed to the EUSS. But some people had to go through this two-stage process. And we've seen a lot of guidance, but none that actually, in express terms, addresses that need to do two different things. You can do this or this, not you may need to do both. Now, we have, as I've already said, Article 18, which shows us what the parties thought an application process should look like. And then we have, in the immediate context of this case, but also we know more broadly, because we have the evidence of what the application process looked like, the information that was provided by the applicant on the form. And it's absolutely clear, you saw the form earlier, that the applicant stated that she was applying to join, stated on her behalf, she was applying to join her brother. It's perhaps surprising that that was a valid entry on this form, given what we've been told about. We don't
Well, of course, some digitised systems would simply refuse to process.
Yes, and it could have been set up in that way.
Computer say no.
Well, yes, and then of course the applicant would have known that it was the wrong application.
Yes.
But that
happens, for example, in digitised divorce systems.
Happily, my lord, have no experience of those.
Well,
either professionally or personally.
Well, I'm in the same position. But it is the fact is that systems like that stop you going on to the next page digitally if you put the wrong invalid information in. And that obviously doesn't apply here.
But what we do have then is the applicant being enabled to give that information, plainly in an attempt at invoking her right to have her entry facilitated as dependent relative of her brother. And I say that is sufficient to bring her within the scope of Article 10.3, because the processes that have to operate within the bounds of EU law in this context can't be such as to defeat an application on the basis that the wrong option is selected on a form. Now, my own friend, I think, says that has made the submission, the procedure for national authorities is simply not bounded by EU law. As I said, first of all, Bangor says in terms that that's wrong, and when it's the argument by extremes, if the requirement of the 2016 regulations was to fill in a form in a particular colour ink or deliver it in person to a location that's not accessible by public transport, clearly in my submission not within the national authority's discretion. So the question is the limit of that discretion to accept an application as being an application for facilitation of entry and residence. I think my learned friend Mr. Cox is going to deal in more detail with Regulation 21 of the 2016 regulations, which you've been shown. I confine myself to 2 points on that. Firstly, it's not relied on, as I understand it, by the Secretary of State in this case as the basis of refusal. There's simply been no consideration of that. What's been put in issue is whether there was an application at all. And secondly, following on from the discussion this morning, it's not actually clear, although I think this may have been conceded by my learned friend Mr. Biggs, but I'd invite the court, if it comes to it, and if it were relevant, to consider whether Regulation 21 would actually be a bar in this case, in circumstances where it was on the right web page, all the questions the applicant was presented with were answered, and it does appear that the information required by Regulation 12 was supplied.
So you say, on one interpretation, it was a valid application.
The dividing line between myself and Ms. Smythe, as I understand it, is whether it was an application at all, not whether if it was an application it was valid.
Right. You say a form which contains all the information required is an application.
Well,
how do you
anticipating a point that I know Ms. Smythe will be making, and picking up on the points that made by my Lady Justice Laing this morning, there is more information asked for when an application is made under the 2016 regulations. So it's not regulation, it's not information, as far as I can see, that is mandated by the 2016 regulations, which is what Regulation 21 deals with. But the Secretary of State has a discretion in a way. So the Appendix EU forms are very much computer says yes. If you provide the very limited requirements that are permitted under Article 18, do you have the required identity document, necessary degree of relationship, document issued under the 2016 regulations, stamp you're in. And the 2016 regulations application process is a more evaluative process. And so the state will ask lots of questions about suitability and all those sorts of things. Of course, we know in this case, it goes to the interpretation of the withdrawal agreement, but we do know that this applicant has passed those tests, and suitability checks, etc., because she's got leave under another part of the immigration rules, which will also have had suitability criteria. But in any event, we know the Secretary didn't ask those questions of her. And all we are saying is that attempting to invoke those Article 3 rights, but by making an application that in form, but not substance, because it can't be, was under the new EUSS process, that attempt to invoke those Article 3.2 rights is sufficient to fix the date of application for Article 10.3 purposes. It doesn't mean that it has to be dealt with as a 2016 regulations application as it stands. The Secretary of State is of course free to ask for more information, to say that you must fill in this form and give me these documents before I'm going to reach a final decision. Or there may be many other ways he could seek to deal with the situation. They're not prescriptive, but the point is that if that application is made, if that attempt is made, to a clear attempt to invoke the Article 3.2 rights through a proper application process. We're not talking here about someone who's written on a slip of paper and handed it in to an official employed. And we're talking about someone who's gone to the website, tried to make the right application, visibly on the face of that application has provided the information that shows that she would have qualified for the anterior step, that she is entitled to be treated, or that she is, within the protection of the withdrawal agreement. Yeah. And then all that requires is the extensive examination of circumstances under Article 10.5, which has not taken place in this case.
So you say then, and I'm conscious we've exceeded your time now, you say that information was sufficient to trigger the 10.5 requirements.
And
Right.
I should just say this as well. I'm not saying that it's any assertion that one is an extended family member. It's an attempt to make an application under that dual process on that same website where those two schemes operate in parallel, and what happens when this confusion that could only arise under this particular system leads to the application being made in the wrong form,
Thank you.
but nonetheless an application. So it's a quite a niche point. I'm conscious that I can't remember which member of the court asked this morning about numbers, but I'm conscious there is an outstanding question about numbers, which Mr. Cox may be able to assist on a bit more than I can, but there are a significant number, but we're not talking floodgates, we're not talking thousands of people. It is a number of people who probably in December 2020 made a similar mistake to this.
Well, Mr. Cox will perhaps enlighten us more. Is there anything more you want to say? We have overrun.
So, well, just one final point, if I may, and that's on the last point which Mr. Biggs addressed you and what could happen as a result of that extent. Yes, but it's not the academic point, but it's the consequence.
Oh, the consequence point, yes.
Which is that you have in the bundle, I don't think anyone's shown you, I'm sure Ms. Smythe will, the EU, Appendix EU and Appendix EU FP. And there's a tortuous series of provisions whereby someone who is an extended family member, like the appellant, in the country now, could apply for leave under Appendix EU. And if she had either a document under the 2016 regulations or, as is explained in both our and the Secretary of State's evidence, now a letter the Secretary of State issues in lieu, because that route has been closed, that would then constitute a document that would enable her to apply under Appendix EU. So she could be put in a position to make an application under Appendix EU. And importantly, and again why my client is here, the content of that right is not just, although it includes a longer term of leave and access to benefits, it's the full protections of the withdrawal agreement. And we know from the IMA judicial review that if she were in that position to then obtain leave under Appendix EU, that can't be taken away, can't be limited. So it is a significant and important difference for any individual whether or not they fall within the withdrawal agreement, even if they have another form of leave under the Immigration Act currently.
Thank you. Thank you very much, Mr. Lord. Now, Mr. Cox.
My lords, my lady. The Air Centre and Here for Good are grateful for the Court's indulgence in allowing us to make submissions. The appeal raises the important question of what limits, if any, are placed by the withdrawal agreement upon the decision-making powers of the Secretary of State in determining an application made before the deadline in that agreement, which an applicant contends was an application for facilitation of their residence in the UK as an extended family member of an EU citizen already residing in the UK. The position of the joint interveners is that the submissions made by the Independent Monitoring Authority are correct, and that Article 10.3 of the withdrawal agreement requires that the Secretary of State's approach to such a contended application comply with general principles of European Union law, in particular proportionality and good administration, and ensure that Article 10.3 is not deprived of its effectiveness. We do not say that the arrangements on the website and the information associated with that, as such, breached the withdrawal agreement. What we do say is that, notwithstanding those arrangements, the withdrawal agreement requires that the Secretary of State have a residual power to allow applicants to correct errors in the making of applications which are or can properly be regarded by the Secretary of State as facilitation applications. What I hope to do is to show why that issue arises on this appeal and to supporting and drawing on the submissions already made by my learned friends to show why that is the correct interpretation of the withdrawal agreement. This case is a paradigmatic example of the value of that power. The evidence provided by the applicant, as you've already heard, The evidence provided to the FTT showed clearly that she met the threshold conditions for having residence facilitated. She is the dependent sister of an EU citizen working in the UK as at the 31st of December. And the evidence, in fact, went further in my submission and showed a lifelong dependence and therefore a powerful case for the favourable exercise of the facilitation power. The single error which led the application to being dismissed was the selection of the wrong form on the website. Now, while that may be primary on the approach of the civil servants who receive these applications, we say that that was from the point of view of EU citizens and from the point of view of the withdrawal agreement, an error of form and not of substance. The issue in the case is therefore not whether the Secretary of State's front of house, as it were, arrangements for receiving applications breaches the withdrawal agreements, but whether the consequences for the applicant of her non-compliance, or as it turns out on the evidence, her brother's non-compliance, is one which complies with the withdrawal agreement. And the consequences, as my learned friend Ms. Ward have just explained, are drastic. The difference between the right to reside here indefinitely, to take any form of work, and the right that she presently has tied to a particular employer is very substantial. The First-tier Tribunal focused solely on whether the Secretary of State's arrangements for the making of applications complied with the withdrawal agreement. That's paragraph 18 and 25 of the decision. The First-tier Tribunal didn't consider, in our submission, whether the application was in substance one for facilitation, and therefore did not reach the question of whether the Secretary of State's failure to consider whether to regard the application as one for facilitation breached the withdrawal agreement. And so we also respectfully disagree with the conclusions of the tribunal below at paragraph 46 that the requirements imposed on the UK by Article 10.3 are met by the operation of a policy of blanket refusal to consider whether an application for a European family permit on the EUSS form is not also is also an application for a European family permit under the EA regulations. And we, like the Independent Monitoring Authority, submit that the outcome in this case was obvious. And I won't press what's already been said to you because I know that the court has only limited time. As to the magnitude of or as to the number of other cases affected, in our written submissions we said that our clients had not been approached by any significant number of persons, but a subsequent analysis by my clients of decisions given by the Upper Tribunal, which are numerous, it indicates that perhaps dozens of people are likely to be within the tribunal system at present. That is, before the First-tier Tribunal or before the Upper Tribunal. Obviously, the Secretary of State is a respondent to all such appeals and therefore may be in a better position to provide more refined analysis, but obviously she has many calls on her resources. Sorry, he. I'm so sorry.
He now.
I know.
He. At the
I've
moment.
been consistently misgendering Secretaries of State, I'm afraid, for some time. I'll try to stop. The bench has asked about the scope of this appeal. Our intervention, my client's intervention, was made in particular because of the importance of the Article 10.3 issue. The appellant failed on that issue below, in particular paragraph 47 of the Upper Tribunal judgment at page 144. The appellant's grounds, page 15, challenged the Upper Tribunal's dismissal of grounds 1 and 2. And ground 1A in particular pleads generally that the Secretary of State failed to comply with the duty of proportionality imposed by the withdrawal agreement. I would accept that the grounds of appeal as presently drafted do not explicitly raise the contention that this is or could have been treated as an Article 10.3 application, but in my submission that's embodied in those grounds of appeal, and it would certainly assist in other cases were the court to feel that it has heard sufficient arguments and taken whatever procedural steps are appropriate between the bench and the full parties to this appeal to be able to give judgment on those issues. But I shall proceed to do what I can to assist the court and leave it really to the parties, the appellant and the respondent, and to the court itself to decide what the proper ambit of the appeal is and what procedural steps, if any, are to be taken. My Lord Justice Dingemans used the phrase late application, or as I apprehend, also a last-minute application, and I wanted to just deal with that briefly. In the case of extended family members, the last date upon which the right could arise, or the last date upon which it could first arise, was the 31st of December 2020. So the withdrawal agreement comprehends people only at that stage having the right to be joined by their family members. Unlike immediate family members, there was no grace period of 6 months in order to make an application down to the 30th of June, and there is no provision for a late application. So in the orderly transition comprehended by the recitals and provided for by the withdrawal agreement must be premised on the basis that a person had the right to apply, and in fact could only, in certain circumstances, apply at the very last minute. The particular facts of this case suggests that the sponsor arrived here in January 2020, and there is some indication.
Regularised in February 2020, and the
Yes.
application wasn't made to December. That's all I was pointing out.
I see your Lordship's point, but the interpretation and application of the withdrawal agreement starts from the point of view that it must be available to people who'd only arrived on the last day. There is some indication in the papers, I don't know the factual position, that he only began working in November 2020. That's at page 374, or at least there's a rather unclear statement there. But in my submission, the court's approach needs to recognise that there is no provision for late applications, and that last-minute applications are of necessity to be comprehended and to be expected.
And the same principles apply to them as would have applied to an application made months earlier.
Well, the same basic legal framework and rules applies, but we do say, and it's the cliff edge point that's also been raised by I think both my learned friends, we say that when making the withdrawal agreement, the parties knew that there could be no possibility of a subsequent application, as my learned friend has explained there would otherwise have been with EID or extending into the future. Mm-hmm. And therefore, in my submission, when considering the application of Article 10.3 for a orderly withdrawal from the European Union and recognising the rights referred to in the recital, in my submission that points to a flexibility of treatment of applications which at least the decision maker may properly regard as applications for facilitation. And so while we do support the IMA's primary point that this was on any view an application for facilitation, we tender to the court a middle position, which is that the Secretary of State's power to evaluate what is in front of her and to decide whether to put the label on it, application under the EA regulations, is one which has never been, the exercise of which has never been considered in this case.
Yeah.
And that's very clear from the Upper Tribunal's decision.
Yeah.
And therefore that middle position, if you like, would be to recognise that the Secretary of State has a judgment to be exercised, a first instance judgment, which is not yet exercised, about whether or not this could constitute an application for facilitation. And we say, consequently, must have erred and breached the withdrawal agreement by failing even to think about it, which is certainly my learned friend's position.
Yeah.
Now, the Secretary of State says that member states are unconstrained by European Union law in the procedural requirements they impose. For the reason that have already been averted, we say that's wrong. We say that in fact the nature of Article 3.2 is a procedural right to have the case considered. And that's clear from the passages already referred to in the IMA's submissions from Rahman, so paragraphs 24 and 25, and the views of the Advocate General Bob. And we say that the procedural rights are of particular importance, and I'd also draw your attention to the phraseology in Ibangby at paragraph 25 of Lord Justice Laws, who spoke of a right to have the application facilitated. So this is not a substantive right to get the permit, but it is, in my submission, a right to have it made possible to make the application, and the standard of possibility must be adjudged by reference to the rights in play, which are valuable, and under Article 10.3, the fact that there is no possibility of a second bite of the cherry. My Lord, in relation to regulation, in relation to Regulation 21, we note that the Secretary of State does not. The position in the first skeleton was that this is not an application, whether valid or invalid, which goes very broadly, but doesn't, in my submission, help the court understand whether the objection to the application is that it's not one that was validly made in the form required for such an application, or whether the objection is that it's not an application at all. The Secretary of State, though, has not disclaimed reliance upon Regulation 21, and in my submission, Regulation 21.4, and if I could just briefly ask you to turn that up. In Divider 1 of the authorities. Six.
Page 130.
Yes. I'm so sorry.
130. Page 130.
And it's the shortly drafted paragraph 4, which brooks no, on the face of it, brooks no exception. The only exception is 6A, circumstances beyond the control of an applicant's documentation under this part. And as a result, the applicant is unable to comply with that requirement. In my submission, that the rigour of that provision goes too far and steps outside the bounds permitted by EU law. Because it denies the Secretary of State the possibility, or purports to deny the Secretary of State the possibility, of entertaining an application which on the face of it is substantially made under Article 3.2 and which she considers ought properly to be considered under Article 3.2. Now that issue hasn't arisen before, for the reasons that have already been explained, that the usual solution was to make a second application. But it arises now, and we say that's precluded by the EU law principles of proportionality and the good administration requirement of fairness. And refer you to our written submissions on that. The Secretary of State does not appear to dispute the existence in general of a power to regard an application like this as one made under the EEA regulations. She does not appear to dispute the existence of a power to disregard Article 20, Regulation 21.4, or to regard it as overset by the withdrawal agreement. So this is not a case where it seems there is a conflict between at the bar as to whether the Secretary of State can do what my clients are proposing she should do.
So if you say she can do it, she ought to do it.
She says she doesn't have to do it.
Right.
And my understanding is that's the burden of her case. She says she doesn't breach anybody's rights by not doing it. And so in my submission, that the case law that we've been taken to on the lack of an obligation to treat an application A as application B, and I can take you to cases in which, as you'll have seen from our written submissions, the Secretary of State did exactly that, did consider whether application A was really for right B. The question is whether or not, in light of the withdrawal agreement...
She has to.
No, I make a middle submission, which is whether or not, in light of the withdrawal agreement, she can refuse even to think about it.
Okay.
Yeah.
And again, you're saying it is he, the Secretary of State.
I'm so sorry.
Yes.
But I mean, that's basic public law, isn't it? I mean, if you've got a discretion, you should think about whether or not to exercise it in a particular case.
My lady, yes. And we also do rely upon the principles of public law in the way in which the Secretary of State gives effect to the scheme in the details as it regards individual applicants. It's said in the supplementary skeleton that the joint interveners haven't grappled with what that would mean in practice for the Secretary of State. And the case that we make on that is quite narrow. We say that it would not be onerous for the Secretary of State to revisit the refusals that she's made under the EUSS scheme, where they're challenged on the basis that the applicant was an extended family member and the application was made before the 31st of December 2020. It's not the case, as my friends say at paragraph 8, that this would mean any situation where a person has made an immigration application claiming to have a relationship with an EU citizen. Our case is that this really relates to this particular block of cases where, faced with this website, which clearly is sufficiently clear for most people, but not for everybody, those who make that basic mistake should be shut out without any consideration of the merits of their argument. And this is, as I've said, a paradigmatic case. The applicant went to the First-tier Tribunal with detailed witness statements from herself and her brother, explaining all of the matters that the Secretary of State would need to have regard to in order to consider a facilitation application, and saying, I made an EA application. Now, I accept that there wasn't evidence before the First-tier Tribunal as to how the mistake came to be made, but it doesn't seem that the First-tier Tribunal judge put that in the balance against her. First-tier Tribunal judge seems to have taken the view that it didn't matter what the explanation was. You tick the wrong box, tough luck.
Well, against the finding that it was clear. Paragraphs 18 and 25, which you've already referred to.
Again, well, and if we look at the case that was put to the Upper Tribunal, the Secretary of State's case to the Upper Tribunal at page 142, which is the case that the Upper Tribunal essentially accepted. Paragraph 142 of the Upper Tribunal's decision records the submissions of the
Sorry, which page are you on? Which page are you on?
142 of the appeal bundle.
Yes.
Paragraph 42.
42. Yes, thank you.
Ms. Ahmed, who was the advocate for the
Yes.
Secretary of State, submitted the evidence in the appellant's application was one which objectively viewed was one under the 2016 regulations was very thin. The reference in the 14 December 2020 letter to a European family permit visa could be taken as either an EUSS application or an application under the 26 regulations. So the Secretary of State's case seems to have been to the Upper Tribunal that it could have been considered as an application under the 2016 regulations. 43, she argued it's the applicant's responsibility to ensure they apply for the correct product and to follow the correct application procedure for it. Ignorance of the law is not a defence. The respondent has set out information about the two different schemes on the website. And the third paragraph, it was unreasonable to expect the respondent to have deciphered the appellant's intention on the facts of this case. With respect to my submission, there is no cipher here.
No.
There is only one thing that this sister of a Portuguese worker in the UK was asking for, and that's to come and live with him.
I mean, do either of the courts below refer to for example, the point made by my lady this morning that the word brother appears on the form,
I don't think they do. I think the reasoning
and in the following page, the relevant material is about dependency is identified.
I think the crucial reasoning is at 46. Bottom of the 140.
Covering letter.
Covering letter did not specifically refer to the 2016 regulations. Well, that's true. But with respect, the applicants can't be expected to know the legal underlying labels that are applied to applications like these. These may be very convenient for the busy officials charged with deciding them, but it's the court's job to strike the balance between administrative convenience and the needs to uphold individuals' rights. The second point the court made, it referred to European Family Permit visa, which objectively viewed was at least consistent with an EU settlement.
Okay, so there's no reference to the other material on the form, which would have given, which, as Milady indicated earlier, gave a pretty clear indication. Well, that's not what you said, but one interpretation gave a pretty clear indication of what was going on here.
And that paragraph concludes that it was not unreasonable for the ECO not to review the contents of the application.
Well, paragraph 3, line 7. I confirm I'm applying for EU settlement scheme. The appellant's brother's details were provided as a sponsor. So it's set out right at the beginning of the judgment.
Yes. But what the tribunal concludes is that it was not unreasonable not to even look at the fact that this quite short application form, commendably short, we don't criticise that the form is specifically drafted for the particular class that it's intended to deal with, refers to him as the brother and explains that he's dependent. So,
I've got an eye on the clock, Mr. Cox. I know you started slightly late, but I'm going to be a little firm about
yes,
when you
my
have
lord,
to stop.
I will be quick. All of these documents were before the First-tier Tribunal judge. So the entirety of the form.
I'm sorry to stand up. Just to be clear, the judges in the First-tier Tribunal, I'm told, and the judges in the Upper Tribunal were taken through that material.
Okay,
the points that my lady made, for example, were made.
Thank you.
The application, unlike other immigration applications, it's not a human rights application. It was made specifically under the scheme for the family members of EU citizens. And in my submission, that really answers the Secretary of State's otherwise unelaborated concern about the scale of the exercise that she would have to undertake if the court found in favour. I will try to be very quick on the secondary points. We submit that reliance upon Articles 14 and 18 is not necessary for the
14 and 18 of
the withdrawal agreement.
Thank you, sorry.
But we do submit, as set out in the written submissions, that they may provide assistance. There is a disagreement between the parties as to whether or not Article 14 applies to the application. You have been shown the note from the Commission. We say that notes from the Commission do not assist in the interpretation of the withdrawal agreement, and we note that in the case of IMA, where the Commission appeared, that the Commission did not rely upon their own notes, their own post-agreement notes, as an aid to interpretation. But what that does illustrate, as a matter of fact, is that applications may be made under Article 18 abroad or via Article 14. We say that the reference in Article 14.3 to family members must, like the other use of family members that you've been taken to, be understood, where appropriate, to include persons falling under Article 10.3, 10.2, 10.3 and 10.4. The authors of the agreement clearly do not use family members only in the narrow sense.
Not used consistently throughout.
No, not used consistently throughout. If extended family members are not covered by Article 14.3, it would mean that even where they've been recognised as meriting facilitation, there would be no obligation to issue a visa, which we say would be an inexplicable lacuna in the protection afforded by the agreement. We don't contend that Article 14.3 confers a right of entry or residence. It's procedural. The procedural duty under Article 14.3 extends to the question of whether to reject a visa application formally made under one label without consideration of whether to regard it as in substance made under a different label. My lords, unless there's anything else I can help you with. Sorry.
Thank you very much. Just give me a moment. Well, Ms. Smythe, my chairmanship has not been quite so good this afternoon. We've lost about 10 minutes, so I think we can sit till 4:10, so we can catch up.
Thank you,
But
Lord.
you're certainly not going to be under any disadvantage because we've overrun slightly.
10 minutes is very impressive, I think. 10 minutes off schedule. But very impressive.
Thank you. What's your next point?
That's it. I sit down and I win. My lords, my lady, can I take matters in the following order?
Yeah.
First is to summarise our response and make some preliminary points. Second, just to look back at the Upper Tribunal's decision.
Yeah.
Third, to deal with some key topics, some key legal topics. Obviously, I won't repeat what has been said, but I do need to correct some of what has been said. Fourth, I'll make submissions in response to the appeal, including the grounds of the appeal, and then finally I'll deal with some mop-up points. So could I begin then to summarise our response by saying this, that the arguments before this court have ranged far and wide, and for that reason it's necessary to recall what the grounds of appeal to this court actually are. So they're in two groups. The first group is essentially that the Upper Tribunal erred in its interpretation of Article 18.10 and Article 18.1r, or it somehow failed to apply the proportionality principle. And second, it erred in deciding that the appellant didn't have a right of appeal under Regulation 36. Now, what we know is that the Upper Tribunal directed itself that whether or not an application had been made was fundamentally a question of fact. And it's clear from its decision that it decided that no application had been made under the 2016 regulations as a matter of fact. There is, so far as I can see, no appeal to this court against that finding, and indeed if there were, it would face a steep hurdle. So in my submission, notwithstanding the wide-ranging submissions which have been made, including those by the interveners, this is not an appeal on the question of whether an application was made as a matter of fact under the 2016 regulations. It's about whether the Upper Tribunal went wrong because it didn't apply Articles 18.10 and Article 18.1r or some other principle. So one has to have those points in mind because, yes, of course, the interveners are keen that various points should be determined, but that is not the way it works in this court, and rightly, this is not a judicial review, and had some of the points been made by way of judicial review, the Secretary of State would be answering them with very comprehensive evidence about why she set things up as she did, why the form was set up as it did, why the appellants and the intervener's suggestions wouldn't work as a matter of practice, and indeed would be inimical to the interests of good administration. So it's important in my submission to stick to the legal issues rather than broader ranging points that the interveners would want determined. With that caveat then, can I make 5 headline points in response to the appeal and the various submissions that have been made? So the first is foreshadowed by what I've just said, which is that the central issue decided by the Upper Tribunal was whether an application had been made under the domestic scheme implemented
By the Upper Tribunal.
by the Upper Tribunal was whether an application was made under the domestic scheme implementing Article 3.2. Now, both tribunals found that no such application had been made, and that, we say, although had one of the judges in this court been sitting as the Upper Tribunal judge, might have reached a different conclusion. That does not mean that the tribunals made an error of law in that respect. And indeed...
Sorry to interrupt, can I just ask, you said a finding of fact made by the Upper Tribunal and FTT. I mean,
yes.
The Upper Tribunal doesn't make findings.
Well, then it's... Yes, it's dealing with the argument and essentially saying that the first tier didn't go wrong.
Right. Thank you.
But what the Upper Tribunal says is it's essentially a question of fact, and no application was made. So to the extent that it was hearing points that hadn't been decided by the first tier, that was its position.
Oh, it had this extra evidence, didn't it?
I'm so sorry.
It had this other statement, which was admitted.
It had an extra
additional,
statement, yes.
Well, it's not entirely clear to me how that came about.
Yes, well, there we are. In any event, we say it didn't really...
And you put in evidence here.
Yes, can I'm going to deal with that.
Well,
but
whenever that's fine. But I understand your point that it's all a question of fact. Tough. These are interesting questions for a different day. But in which case, why is Secretary of State putting in evidence for us?
Well, the reason that the Secretary of State put in it, the Secretary of State turns up to the Upper Tribunal with a clear finding from a presidential panel in Batul that her guidance is very clear, rejecting an argument as is made in this case and saying it was clear to applicants what they were supposed to do. So there was no reason for the Secretary of State to put in any evidence in the Upper Tribunal or elsewhere about the guidance. What happens, of course, and I'm afraid based on experience in Chelik, is that the interveners then perhaps expand the scope of the arguments and put their own evidence in.
Well, interveners often do that.
Yes, indeed, and one doesn't criticise them for that, but it doesn't. It doesn't.
You are
well,
criticising.
it's not a criticism.
Well,
but
perhaps it's the
once,
court's fault for allowing new evidence on appeal.
Once they
without
do
thinking about
that,
it.
indeed, once they do that, the Secretary of State got a finding from Batul that the guidance is all clear. Once the interveners say, aha, we're going to put in evidence ourselves on the guidance, the Secretary of State is bound to say, well, hold on, it's not your fault, but that's not entirely accurate. So I need to put in evidence to correct it. If the court disregards all the evidence, so be it. We're back to what the Upper Tribunal said in Batul, which is essentially the guidance was clear and people should have known what they needed to do.
Of course, it's quite clear. I'm coming to this case as we all do. We three do afresh. You can see how it's all expanded. The proliferation of skeleton arguments, argument upon argument. But that we are where we are.
We are where we are, indeed. But that's why we put in evidence. We felt that we didn't really have much choice once the interveners had put in evidence that we didn't think was complete. And
But
again,
you don't nail your colour to the mast of. This was a decision of fact. That's it.
well, that's the first point I'm making. There isn't an appeal against that finding and the decision of the upper tribunals that an application was made. It's attacked on a different basis, which is Article 18.10 and Article 18.1r. We say that whatever that views may differ as to whether or not that should have been treated as an application, the question is, did the first tier or the upper tribunal err? And they did not in our submission. I'm still on my first point.
Yes.
Just to be clear, Regulation 21 is a red herring. In the sense
This is still one, is it?
Yes, it's still one. I'm just
It's a
dealing
red
with
herring.
was an application made or not. The upper tribunal's primary point is an application isn't made, so we don't have to worry about Regulation 21. But its secondary finding is, to the extent that Regulation 21 is engaged, this was not a valid application. Again, no ground of appeal attacking that finding, and the Secretary of State says, well, that's right. One doesn't get to that point because there was no application. But we seek to uphold what the upper tribunal said about if there was an application, it wasn't valid. So that's really point one. Point two, we say quite clearly there was no breach of Article 3.2 of the withdrawal agreement, which was the governing provision here.
3.2 of the withdrawal agreement.
I'm sorry, of the directive.
Citizens' Right Directive.
Already going wrong. I haven't.
No, don't worry. It's just otherwise my note was going to go haywire.
Yes, we don't want that. There's no breach of Article 3.2 of the directive.
Citizens' Right Directive.
Exactly. And that was the governing provision. That's the second headline point. The third is a general point about the withdrawal agreement. And in that respect, it's necessary to take a step back and look at what the withdrawal agreement was doing in Article 10. All it was doing was imposing a cut-off date by which EFM applications needed to have been made under the domestic scheme. It's doing that because, as Miss Ward showed the court, that there's a cut-off essentially at the end of the transition period. But all it's doing is saying, right, the UK's left the EU. If you want to take advantage of the extended family member right, you need to have done so before the end of the transition period. And unlike for other types of application, it did not include any provision for extension of that deadline. So there have been lots of complaints about, well, there's a cliff edge, and we need to change how Article 3.2 applies basically to defeat the cliff edge. But the cliff edge comes from the withdrawal agreement.
So Article 10 imposes a time limit. That's your point, isn't it?
Yes. What the withdrawal agreement is doing in Article 10 is saying, if you want to take advantage of extended family member rights, you need to make your application by the end of the transition period.
Would you just show us where it says that?
That's Articles 10, 2 and 3, essentially. So you've been taken to those, and I will come back to them, but it's in effect a headline point that's all it's doing. The withdrawal agreement's got to sort out the mess that's created by exit. So it has to decide, right, okay, how long can you keep making these extended family member applications? Because the UK's left, so these rights are going to end. So what it does is say, right, you've got to make the application by the end of December 2020. That's all it's doing in Articles 10, 2 and 3.
I mean, isn't that arguably, and Ms. Smythe will no doubt correct me immediately if I'm wrong, isn't that arguably looking at the wrong end of the telescope? Because what it says is that the rights continue provided they're made by the applications that have been made before where the applications have been made before the end of the transition period shall continue to be protected. My paraphrase, isn't that what it says? It doesn't actually say it's the time limit. Impose the time limit.
Well, it is imposing a time limit because if you don't make...
You have to have applied before the end
Yes.
of the transition period.
Exactly.
Otherwise, you're not within the scope of the protection.
It's imposing a cut-off in the same way as in Chelik. If you didn't manage to get married by the end of the transition period, whatever the reason, you've missed the cut-off for coming in as a spouse. So it is, whatever you want to call it, a hard deadline, a cliff edge, it's imposed by the withdrawal agreement and it arises as a result of the UK's exit. So it makes it all the more important that people get advice if they need to, that they make timely applications, that all of those things, because the withdrawal agreement doesn't say, but you can actually make an EFM application later. It says you've just got to have done it before the end of the transition period. So the third point is really that yes, there is a hard deadline. Yes, it may lead to difficulty in individual cases, just as in Chelik, Mr. Chelik couldn't get married, but that arises from the withdrawal
Well, he
agreement
could get married,
itself.
but it wouldn't help him.
But too late
Yes.
because there needed to be an exercise of EU rights. So that is the third headline point. The fourth headline point is that Article 18 simply did not regulate the Article 3.2 application process. It's a separate provision, it's doing something else. What it's not doing, Article 18, is changing the rules on Article 3.2 applications, and I'll explain that in more detail, and it will become clear, I submit, when I show the court the provisions in the withdrawal agreement. And then finally, even if all the legal principles relied on by the appellant and the interveners applied, there's been no breach of them by the Secretary of State, because what she needs to do is make it possible to obtain a decision on an application. She did. She carefully set up a bespoke application process which was designed to elicit all the information that she needed to enable her to decide the Article 3.2 application, and she gave guidance which was clear, telling people what they need to do. So in our submission, any argument that she has somehow not made it possible for people to obtain a decision, or that she somehow undermined or undermined the effectiveness of Article 3.2 is simply wrong. So that's our final headline point.
Can I just ask this, as I asked Mr. Beeks? So, I mean, it does come down to the question of whether a 3.2 application was made, because you accept, don't you, that if it was made, there hasn't been any consideration of the circumstances.
Yes.
But if it wasn't made, then you say you complied with everything.
Yes.
Thank you.
And to be clear, of course, the obligation, and tied to your Lordship's question, the obligation to decide the application can, of course, only arise if it's made.
And where does it being obvious, not necessarily to the people schooled with what Ms. Ward talked about in the great submissions, but anyone looking at these applications would realise that they've just put it in under the wrong box. Where does that fit in?
Is your Lordship asking me whether I mean, I think our point is that we put in place clear guidance.
Yeah.
And the reason that the Secretary of State, and I'll explain this when I come on to deal with my topics in more detail, the reason that the Secretary of State set up 2 application processes was so that people could apply for what they needed to. She has to have 2 application processes because what she needs to know for a 2016 regs Article 3.2 application is different for what she needs to know for other applications.
Yes, but anybody knowing what they were doing, as the person reading these documents did, would know within 90 seconds that this was an application under the wrong.
I don't.
I mean, it says
We don't agree, my lord, and neither did the Upper Tribunal or the First-tier Tribunal or the Presidential Panel in Batul, and they are obviously very experienced in dealing with the immigration system. So in my submission, that's not correct, and it may be why that particular finding hasn't been challenged. The Upper Tribunal gives reasons for that, and again, being familiar with the immigration system, being familiar with the need for predictability, rules, fairness between applicants, systems built on rules so that everybody knows where they stand, so that applications can go to the right bit of the Home Office and not the wrong bit. There are lots of applications, and so if an application is made on the wrong form, that creates, and we've said so, indeed, Mr. Cox didn't read this bit of the Secretary of State submissions. He cut his submissions off at this paragraph when he was looking at the Upper Tribunal. But the submission was made is that actually there are a lot of applications. It would be very difficult. This court is only looking at one application with the benefit of a huge number of submissions. The entry clearance officer decides lots of applications. The application that went to this entry clearance officer is a family permit application, and that's what this entry clearance officer is dealing with and is set up to deal with, which is why we make the point about, well, we've got these systems so that applications go where they need to. So it's all very well in my submission for all of us to say, oh, well, come on, that was obviously such an application. That's not in my submission how it works, and it's precisely the sort of JR where the Secretary of State would want to put in evidence about her systems and why she sets up her systems as she does and why this wouldn't be a good way of doing things.
And does that cover, sorry, just while we're dealing with this point, and does that cover the secondary point, which was, fine, we understand the Secretary of State's under a lot of difficulty administratively, but in those few cases, because not everyone renews, in those few cases that come up to the courts, then the courts have the obligation of vindicating the rights.
Well, those instructing me, again, probably a point for evidence, but those instructing me would say, well, we consider that we've got a duty to have a system which is fair as between applicants. So if it's to be, well, it just so happens that I've popped up and said you should have done this, what about somebody who pops up a year later? What about somebody who didn't pop up? What about...
Does the principle of being fair between the applicants appear anywhere in the directive?
No, we would say it is part of general good administration,
obligation under the
general
directive
public
is to-
law
The obligation.
principles.
I'm sorry, forgive me. Forgive me, I interrupted you.
We would say, I mean, it's certainly something the Secretary of State would seek to do as a responsible Secretary of State, and the Home Office would want to do as a responsible public authority. So it's all very well to devise solutions that might seem justified to the interveners on the facts of this individual case, but there's a whole background here which is not in evidence before this court, was not in evidence before the Upper Tribunal because it wasn't an issue, and also because it's not a judicial review. But the Secretary of State's not trying to be mean here. We say it in paragraphs 11 to 13 of our skeleton argument. What she wants is an efficient system built on rules which is able to administer so that things go to the right place, are dealt with by the right people, and resources are limited. And it's a bit like the old cases on the points-based system. But that is a fundamental principle underpinning the immigration system.
I don't think anybody sitting in this court could doubt the enormous difficulties that those who administer
Yes.
the immigration system in this country, the difficulties they face day in, day out. It must be very, very challenging and no doubt with restricted resources.
And one has to remember, of course, the point about the cliff edge cuts both ways, because the Secretary of State had limited resources and at the end of the transition period was facing lots of additional work because of the new system that was put in place and because more applications were being made. So in our submission, far from saying, well, that's all the reason to start disapplying rules and deciding things on a case-by-case basis, it's actually the opposite. It's important that there are rules and that people follow them. Yes, if the Secretary of State sets up a rubbish system that people don't know what they're doing, fine, but she didn't. She set up a system which the Upper Tribunal has decided was accompanied by clear guidance.
Well, wasn't the fundamental obligation under Article 3.2 to facilitate the entry of those who had a right to enter?
Well,
if I may just finish, and to investigate the circumstances and justify any denial of entry on, might one say, substantive grounds.
My Lord,
isn't that the fundamental? My point is, isn't that ultimately the fundamental obligation, which should take precedence over the procedural complexities, which, understandably, you're stressing?
No, that's part of the obligation, but the first part of the obligation is to make it possible to obtain a decision on an application. Once an application is made, of course there is an obligation to consider it, consider whether or not the person gets through the threshold, consider whether or not discretion should be exercised in their favour. But first, the Secretary of State needs to set up a system for dealing with the applications. That's what the court says in Rahman, to make it possible for them to obtain a decision on their application, which is founded on reasons.
Well, there's no reference in Article 3.2 to that point about there being a sort of precondition of there being an application before the Article 3.2 responsibilities kick in. Is there authority which supports the proposition?
Yes, Rahman. There is,
okay.
And I will.
You're going to come on to that.
I will.
Well, I know this is just a general traverse of your overriding argument, so we'll come on to it in your own time, Ms. Smythe.
Yes.
Probably tomorrow, I think.
He said nervously, looking at the clock. Yes. It's really before I come on to the meat, I was addressing a point from Lord Justice Dingemans about evidence and so on, and we've obviously now I've made some of my submissions. Could I make, so my preliminary point was on the point about evidence, one, why we'd put it in, and two, the evidence this court is lacking because it's not a judicial review.
Yeah.
The second point in relation to Commission guidance, I'm sorry that I started this, the only reason that I referred to the Commission guidance in the skeleton in the background part was because it's quite a helpful explanation of what Articles 10, 2 and 3 are doing if somebody's being introduced to the subject matter. To be clear, we absolutely say that this can't be used for interpretation, and indeed the Commission say as much, and we will provide this tomorrow. But what the Commission say on the front page of the guidance is this. I'll just read it out. This guidance note is purely informative and does not supplement or complete the agreement on the withdrawal, so in other words, doesn't supplement or complete the withdrawal agreement. While this guidance note has been prepared by staff of the European Commission, the views contained in the guidance note should not be interpreted as stating an official position of the European Commission. So that's the only reason I used it, just because I thought, well, they've explained that quite nicely as an introduction, but we absolutely don't. And I think the bit that we've relied on wasn't controversial, it was just convenient. So I wish I hadn't done it.
So your submission is that we can't take it into account in
Yes.
considering the agreement.
Yes, and I won't.
But it's a useful introduction to what's going on.
It just explains it quite nicely. That's all. I think it's in the background section. So
And it's never been adopted by UK government.
no, and indeed the UK government says some of it is wrong, which is precisely why there isn't an agreed version of the guidance. And at one point, as I've said, it was hoped that there would be, but agreement couldn't be reached.
Will it be? Oh, never mind. I would detract from your time.
No, please,
leave that
please,
point.
please
No,
do.
it's not relevant. Carry on.
The final
It's an
point.
interesting point, but I mustn't
Very
distract
nice.
myself. Carry on.
Very many interesting points. The final point, just to mention, is on the academic point. It's very simple. It's that because she has now entered the country, I realise perhaps the wrong word, because she has now entered the country, she is now no longer eligible for the very thing which this appeal is about, which is an EEA family permit, and I'll show the court that in the
Because
ruling.
she's now in the country,
Because
she's no
now in the
longer.
country. Yes. So she's not eligible for it, and it would be the same. Supposing somebody made an application for an EEA family permit and then thought, "Oh, this is taking a long time to get determined. What I'm going to do is find a different way to go to the UK," and they did. If the position would be exactly the same there. It's simply that because she's here already, she's no longer eligible for an EEA family permit. Now,
We haven't looked at this. Did she apply for? Did she apply for leave? What happened?
what
Or
she's
did you
got,
grant
we
it,
know.
as it were, voluntarily without? How did that come about?
This is the very problem. She's saying now that she wanted to apply under the 2016 regulations. What she applied for was entry clearance under the EU settlement scheme. But this argument goes to the point that, well, she did make an application under the 2016 regulations. It doesn't get her anywhere in our submission. And it doesn't do to say, oh, well, she should be granted leave outside the rules. We saw in the case law, when Mr. Biggs took you to the case law, including Lord Justice Burnett's point, if you want leave outside the rules, you need to apply for it. This appeal is just about whether or not she is entitled to an EEA permit, if Mr. Biggs is right, and that's the appeal that's being made. So I appreciate...
There have been submissions made about consequentials. What would happen if the appeal was allowed? What would happen after that? Which presumably you'll come on to at some point tomorrow.
Again, yes, I can explain that tomorrow.
Yeah.
Depending on the precise basis for the appeal being allowed. That if the Upper Tribunal had decided that she had made an EFM application, then it would have been decided, subject to the point about her being in the country. And what happens, as I think others have explained, is because the Secretary of State isn't giving those out anymore, it's done with a letter which then entitles somebody to leave under the EU settlement scheme. But I'll explain, it's explained very precisely in my client's witness statement.
Okay, we'll look at that tomorrow, shall we?
Yes.
Right. So has that complete your...
That has, and
horizon
some
five
initial
principles,
points. So
5 points.
could we then look at the upper... Perhaps we should start with the first tier's decision, which is
Yes.
in the hearing bundle at page 217. So the core of the reasoning begins at paragraph 16.
Could we look at the refusal letter?
Yes?
Just if we're going right back to basics, as it were.
Page 236.
Okay.
So this is a decision on the application that was made, and it's page 237. Essentially says you aren't a family member, which, as we discussed earlier, is a close family member. And so therefore you don't meet the eligibility requirements and your application is refused.
This is really a standard form letter with the odd date put in, isn't it?
Which is,
I can't imagine any of this is, apart from the date, perhaps one or two other things is particular to this application.
precisely, and this is how this particular application is decided, by reference to the rules, in the same way that a points-based application might be, other than any additional assistance that's provided, but that is not engaged here. But this is essentially, you don't meet the rules, so the application fails. Now, what's being said against me is, well, it wasn't good enough for this entry clearance officer to refuse it. The entry clearance officer should have gone ahead and treated it as a 2016 regulations application and decided it as such, or gone back and said, well, is this what you plan to do? And as I submitted earlier, the presidential panel in Batul and the Upper Tribunal in this case said, no, that's not a reasonable thing to expect this.
So the whole facilitation obligation, as it's been called, doesn't arise.
Not if an application isn't made. So, and we'll see that in for example, the Macastana case, where, and Mr. Biggs took you to this, where the person said, I am a durable partner, and did so in a particular application, and the court said, and it was an application, I think, for to leave the country or something like that, so it wasn't an application for leave. And the court said, well no, that's not good enough. And I appreciate that the facts are slightly different, but nonetheless, I submit it's powerful authority. We'll come on to that. So that's the
Okay, thank you.
That's the decision.
And then we get the FTT 217.
So the procedural history at paragraphs 3 to 6.
Yeah.
And then the submissions. And one can see at paragraph 12 that squarely the Home Office presenting officer, this is on page 218, is saying that effectively that the submissions in paragraph 12, there is no application under the 2016 regulations. And then the arguments made in paragraph 13 and 14 that it should have been considered as a different application. And then at paragraph 18, the First-tier Tribunal says that the applicant had confirmed that she was applying as a close family member. In other words, she was making an application under the EU settlement scheme. And then the judge deals with a submission that was made on a case called CP in paragraph 21, and makes a point at the top of page 222 that case also said that an immigration judge is not under an obligation to embark upon a roving expedition among the rules. But then at paragraph 22, what the first tier says is, I don't accept that there's a legal duty on an ECO to apply any other law or application criteria other than that under which the application was made. And we already know from paragraph 18 which application this tribunal has decided has been made. The ECO in this appeal, and this is at the end of paragraph 22, was under a duty to apply the correct immigration rule within the immigration rules. but wasn't under a duty to consider or apply any law or regulation outside of the immigration rules. And then a very clear finding at the start of paragraph 23, this application was made under the JUS scheme within the immigration rules and not under the 2016 regulations.
Hang on, where's that?
Paragraph 23.
So she had two options open to her, and this was what she chose to do.
Yes, she didn't. She made the JUS application. She did not make an application under the. So that's a finding of the first tier, that is the application that was made. And then again, it's simply more effectively paragraph 24. There were two distinct application routes. Paragraph 26 again, just if the court was working from a hard copy below the top hole punch, the appellant was able to apply for an EEA family permit, but for reasons unknown to the tribunal selected the category of applying for a JUS family permit and confirmed this in her application. So the first tier is very clear in its decision, and despite having heard quite wide-ranging arguments, albeit not from counsel now instructed, rejected the argument that she'd made an application under the 2016 regulations. So that's the background. So the Secretary of State is successful in the first tier, and it then comes on to the Upper Tribunal with now Mr Biggs and Mr West, who are counsel now. And the Upper Tribunal considers a number of different issues. So could I pick things up under what's described as being ground 1, which is the Regulation 36 ground, beginning on page 140. So, and my Lord Justice Dingemans was quite right to pick me up on this, because obviously the starting point is the first tier's finding, and the Upper Tribunal correctly directs itself. The effect of these submissions is that whether or not the decision in this case was an EEA decision, this is at paragraph 39 for these purposes, becomes a largely factual one. It's necessary to determine whether the respondent and thus the first-tier tribunal erred in not treating the application as one made under the 2016 regulations. And the tribunal finds that it did not err. So we see at paragraph 40 that it was argued that the appellant intended to and in substance did make an application under the 2016 regulations. And then reliance is placed on a case called Ahmed at paragraph 41, which is in the bundles. And then Mr Cox took you to paragraphs 42 and 43. He missed the bit of the Secretary of State's reasoning at the end.
In which paragraph?
Paragraph 43.
Yes.
Where the Secretary of State said the consequences of a ruling that the respondent is obliged to consider an application made on one basis as if it were made on another is likely to be significant. And then explains why. And points out at the very end that reliance on intention in this context is problematic in principle and could have adverse consequences for applicants. Because, of course, although Mr Cox says, well, it's just these particular people and these particular applications, of course somebody else will say, well, why just those particular people and those particular applications? Why not me? So that's why, essentially, the Secretary of State is saying this is problematic on all sorts of levels. Paragraph 44...
I suppose you could also say that if the Secretary of State says, oh, this appears to be application A, but I construe it as application B, the applicant might have something to complain about.
Yes, because and the difference in Ahmed, and this is the precise point, is that Ahmed and the Secretary of State is not now appealing Ahmed because it's different on its facts. In Ahmed, there was a cover letter which said, effectively, I am applying under the 2016 regulations, and it cited the relevant case, the relevant regulations, case law, and dealt, therefore, with the relevant things that need to be dealt with for an EFM application. So the Upper Tribunal distinguishes Ahmed when it's deciding whether the first tier erred in law in deciding that there wasn't an application. And at paragraph 46 says the position was different in this case. the covering letter didn't specifically refer to the 26 regulations.
But it wasn't just the covering letter, was it? It was the information on the form itself.
Yes, can I come back to that in a moment, just to explain something? So to answer my lady's point, in that case, there couldn't have been a problem for the applicant because they had said, well, this is the application I'm making. And on the facts there, the tribunal said, well, you dealt with what was relevant and you described it as a 2016 regulations application. To answer my Lord's question, the form, just to be clear, that's free text. Which relative are you relying on? There aren't drop down boxes for that. So somebody filling in brother, they can just fill in brother. Now I appreciate the submission has been made, or it's been suggested that the Secretary of State, what the Secretary of State should have done is somehow stop the application being made at that point. But again, those are things that we would want to deal with in evidence as to whether that would have been appropriate given the system, given the applications that might be made. But certainly, so it's meant. I'm sorry, my lord.
No, I'm sorry. At some point, I've got a point. You finish your point.
That's what I was saying there. So
I am sorry. I know it's irritating. When
not at all.
When judges do that, and I apologise, Smythe. Can we look at the form? Where is it?
Look
Go
at
back
the
to the
form.
form.
Yes, it's at the back of. It's at the back of the bundle. It is at page 367.
Because you've just given us a bit of information, which I think is possible.
Yes. So this is
evidence about the form.
Yes.
So you're giving.
Although
that's all right.
yes.
So here's the form at 367.
Yes.
And it's a 7-page form.
Yes, and just to trail for excitement for tomorrow, what I will show the court is the guidance on extended family members, which shows the various things that the Secretary of State takes into account and therefore asks for on the correct form, which is not on this form. So, yes, select the category you're applying for, close family member, and the court looked earlier on the evidence, which may or may not be in play, that there's a chance to have a look and see what that is before clicking that button. And I fall back on the point that the guidance was clear about who did and didn't qualify. So page 367, close family member, and then there's a second chance to check. I confirm I'm applying for a JUS family permit.
Now, you've said that this is a print-off, I think is what you said.
Yes.
So this isn't what the... Am I right? This isn't what the person filling in the form would see
No.
when they're filling it in.
No.
And possibly not at any point thereafter.
So, yes, so what happens is that it will look different depending on the answers that the person's given. Now, we did not in our statement put in detailed...
I'm only smiling because this is evidence, isn't it? But
yes,
never
but
mind,
I'm saying
carry on.
Yes, various submissions have been made submissions have been made about what the form does and doesn't do, which I, again, feel bound to correct. But what I can explain, I don't think this is in dispute between the interveners and me, who've seen our witness statement, that the form will be different depending on what somebody fills in. So there are a number of possibilities. One has to sit, and indeed those instructing me did do that, sit and plug in various answers to show what comes up and to show what
well, that's what happens with these semi-digitised processes. So you referred to some of this being text that you... So on page 1, application category, that's something the computer offers you. So that's what you've clicked.
Yes.
But give us an example, if you would, of some text.
Page 371, brother. Yes, my learned friend Miss Ward is saying names. Yes, of course.
Good point.
But brother on page 371.
So all the sponsor details.
Yes, so relationship to you. My instructions are that is free text. And of course, then when did they arrive? That would be free text.
Okay. And then the documents. So on page 6, under the heading documents, how much of that would be free text?
Can I turn my back for a moment, if I may?
Yes.
or would it be more convenient
Do
if
it
I
tomorrow.
check with the expert overnight and then explain? But essentially, that there will be options. Now, the reason, and I'll be corrected if I'm wrong about this, the reason that there are options in relation to dependency is because close family members may need to show dependency.
If you're over 21.
If they're over 21, exactly.
Direct descendants over 21
Exactly.
need to show dependency.
So that's why. That's why the person would have been able to plug this information in. But of course, had whoever.
I mean, the boxes start on 331 in your witness statement, looking at this dependency at the moment, when you choose your language.
Yes, so what you see on select your language, and then there's the landing page on page 333, and then the court will see between the two hole punches before you apply, read the guidance about eligibility and required evidence. And then, as Mr. Peckover says at paragraph 29, this page it prompted the prospective applicant to click on the links provided to find out if they were eligible. And the reason that we included this is to deal with the point about guidance, because the guidance is not just at large, there's also links to it within the online form.
Yes.
So that's why it's there. We confined what we said about the application process to anything to do with guidance. So this isn't a full account of the application process. It's simply referring to guidance. And the reason it's not a full account was that we didn't think that was right, given that all we were doing was responding to a witness statement on guidance. But what this does is show that all the options are there at once, if you like, on page 336, and that before that happens, on page 335, there is another opportunity to read what is a close family member. And that's, the court can see then on page 335, a dependent child or grandchild, which is why the form will have an ability to provide documents on dependents. But what it doesn't have is what would have on the EEA form, as Ms Ward has helpfully already pointed out, that the form will be a lot more detailed because it will ask about things like the exercise of treaty rights, like conduct and so on, because there are a range of factors that the Secretary of State takes into account. So she's designed the forms to get the information she needs to decide these applications, and the idea is not that you have a going back and forth to sort it out, but simply that the person fills in the form and therefore provides the Secretary of State with the information that she needs, therefore facilitating an expedient and an expedient determination of applications, because the Secretary of State's got to decide a lot, and if she spends time going back and forth with applicants, she's not deciding other people's applications. So that's why there are the two different forms. So all I can say really, because we don't have a hypothetical case of somebody who did apply correctly, but they would be giving a lot more information on their 2016 regulations application form.
I see it's 4:10. Do you retire from your first submission this afternoon, or are we still? How are we doing in terms of time?
We're in the Upper Tribunal's decision, although we've anticipated a lot of my submissions, so that will help cut through things tomorrow.
Okay. Would it be a convenient point to stop now?
Certainly, my lord.
Thank you very much. Anything else? Is that all right? All right for you? Well, thank you all very much. Look forward to seeing you at 10:30 tomorrow.